Welcome to Paul Weiss Waking Up with AI, a podcast from Paul Weiss featuring your hosts, Katherine and Anna Gressel. The only update you need on AI policy, law, and governance starts now.
Hello and welcome to today's episode of Paul Weiss's Waking Up with AI. I am Katherine Forrest.
And I'm Anna Gressel.
And Anna, I know you're about to go off to Abu Dhabi again. And in fact, we may even be airing this when you are in Abu Dhabi.
Yeah.
The place that I think you go to almost more than any other place, maybe even more than you go to the Upper West Side. Like, have you been to Abu Dhabi more often than you've been to the Upper West Side, like in the last 6 months?
No, that's false.
Answer it honestly.
No, because my dog loves Central Park. So the Upper West Side is in our normal routine. She loves to chase squirrels. So we take her and we indulge her just huge love of squirrels on the weekends.
Do you know how much PTSD your dog is responsible for in the squirrel population?
Not any more than like every other dog. They're all like parallel chasing together.
Poor squirrels. Anyway, okay. So I am excited about this episode that we're going to be doing in our current time zone, which is the same time zone. Because while we've done some really technical podcasts recently, we're going to go back to our roots for a brief moment today and talk again about AI and evidentiary issues. We've done this once before, but we're going to take on some different evidentiary issues today and actually do some issue spotting for some that we're not even going to really fully go into today.
This is great. And I almost feel like we should be offering CLE credit for it, except we don't have a way of tracking all of our listeners across platforms. But it's a really interesting topic, and it's one that gets a lot of attention at legal conferences today. And I know you have a lot to say about it. I think it's super interesting. We talk about it with judges. It's just a huge area. So why don't I turn it over to you to kind of get us back into this topic? Because it's been a while since we talked about it.
It is. And it's funny because as a former judge, it is one of the things I get asked about a lot. And of course, I was off the bench at the time that these evidentiary issues really started to become something that was front and center of what judges are having to deal with now. So my knowledge of the AI issues, the evidentiary issues relating to AI, is from my time now back as a practitioner. But let me start by putting out a sort of a group of certain AI evidentiary issues that come to mind, and then we can sort of kick it off that way. You can throw in a few, and then we'll just pick off a few to jump into in more depth. But there are, for instance, all kinds of ways that AI can be used to create realistic photos or videos. And we've talked about that in prior episodes. And they can be used to create demonstratives, for instance, accident reenactments or reenactments of crime scenes, or even how an invention works. And whether those should be allowed or not can create a whole host of issues, some of which are 403 issues, which means are they unduly prejudicial, among other things. And the word there that people have to focus on is the word unduly. And then there are other evidentiary issues for AI, which I actually think are super interesting, which are hearsay issues. For instance, when a chatbot responds to a query and there is then a digital record of that response, if there's a lawsuit that follows where that digital record still exists, it might be requested in discovery, and then it might be sought to be admitted, or to put it not in the passive tense, someone might seek to admit it for certain purposes. And the question is it for a hearsay or non-hearsay purpose? What are the issues there? And then there are testimonial issues, which surely we will not get to in depth today, but things like a chatbot or a combination of chatbots that can actually act as a person in a way and have a conversation. And you can then have certain kinds of issues relating to, for instance, the confrontation clause, depending on how those are used.
I have a few more. Can I throw in a few?
Yeah, throw them in.
So what if a chatbot is hosted by a third party and someone interacts with it and then believes they've been harmed by the response? Can the information that the chatbot gave be requested as a document in the litigation? And what are we going to do about experts? I mean, I love experts. I love this topic. There are a few issues that come up among many potential issues. But first, there are all kinds of ways in which courts might find expert testimony useful in disputes relating to AI. But who is qualified to be such an expert, particularly, in this world in which the technology changes so frequently? And separately, can the expert use AI to assist them in writing a report? And that's a pretty live issue these days.
That's a live issue in the fourth grade. It's a live issue in college. It's a live issue in law school. And it's a live issue for experts. All right. So let's pick these off. Let's just take a couple of them for today. You want to start?
Yeah, I'll start with that last one just because we're on the topic. So let's talk about experts. Rule 702 of the Federal Rules of Evidence and case law, including the famous Daubert case and many other cases in every jurisdiction, govern the admissibility of expert testimony. And the two scenarios I set out really have the same basic points in play. First, experts have to be qualified in the field in which they're seeking to provide testimony and opinions helpful to the trier of fact. And second, the testimony also has to be reliable. And it's true that there is a call for all kinds of AI expertise now in a variety of cases, some pertaining deeply to major questions about AI, others in which, AI is kind of less of a central factor, but still important. And those cases might involve how models work or how they learn or what they've been taught or how they arrive at answers and even how the users use the AI to do all of those things. The role of the individual user can be really important.
Right. I mean, I think that our audience may be familiar with some of the cases in the AI area today that are out there, and there are a number of them that are employing experts.
Definitely. And the key is not that there has to be a long history of a particular type of testimony, but whether a person offered as an expert has the right qualifications. So, for instance, if it's a case in which an expert relating to how a model is trained is useful, then finding someone knowledgeable and who either has firsthand experience in model training or someone who's studied it and written about it, that might be an academic, both could be among the kinds of people who might have the right expertise for that case.
Right. There's not one kind of expertise that an individual has to have. It's all really a question of whether whatever the expertise is that the person has, whether it's academic or research or hands-on, whether in connection with the proffered testimony, the gatekeeper to the evidentiary proceeding, which is the judge, finds that that information would be useful either to the judge as the trier of fact or to the jury as the trier of fact. And that's really based on whether or not this individual can speak knowledgeably in the area and is able to ground his or her statements in ascertainable literature or experience or some basis other than just ipse dixit, which is, I say, therefore it is.
Yeah,
I'm not sure that that's an exact translation, by the way, but it's close.
But it comes up in like every Daubert challenge. So, we gotta mention it here. But I think that's a great point, Katherine, that expertise can be grounded in literature, in facts that are in books, for example, a review of that literature, or can be lived experience. I mean, experts can testify based on a huge volume of their own experience. That might be someone like a business expert. So experts come in all stripes and can be useful in all different kinds of points and have very different kinds of qualifications.
Hey, can I just, I want to interrupt you though, because I have to give an anecdote. I never really do this, but I have to give an anecdote because when I was a judge, I had an expert who was proffered. An individual was proffered as an expert who had not graduated from high school and had not gone to college and was an expert in some form of radio wave technology. And the other side, one of the sides, the side that was opposing the expert, was really actively trying to get this expert precluded and used the lack of the formal educational qualifications as a way of trying to sort of solidify their objection. And it turned out that this individual had expertise relating to radio waves going back to the age of 7 and was able to cite all kinds of hands-on things that they had done, companies that they had consulted for, because a lot of companies had not cared one way or the other about whether or not the individual had a formal education. And this person was a true expert. So he was qualified and the case went on. And I don't even remember how the case came out, but it is sort of an example of how.
I think that's a great transition point into our other question, which is like, say you have an expert. What can that expert actually say and do in putting together the report, which is the basis of their testimony? It's not the full scope of their testimony. Of course, you usually have a deposition and the expert expands on their testimony. But let's talk about the report process. So in terms of using AI to help draft a report, it really comes down to this question. Is it the AI itself that has the expertise in the field of the inquiry, or is the AI simply helping with like the wording and just kind of putting it together?
And, there was a case recently in which a proffered expert was found to have had portions of their report written by AI, and it did not go well.
Yeah, apparently that expert had not even checked the content. Maybe this was one of those down to the wire drafting processes.
Who knows what the reason was, but that was obviously a sort of a fatal mistake. We always tell people, you've got to check. You've got to check the content if you're going to be using AI. It's just a tool. There may be a point in time when AI is better than all of us, but we're not there yet. And so AI really needs to be just a starting point if you're going to use it. The case that we're talking about is a case called Coles versus Ellison, and that's Kohls versus Ellison. It was from the District of Minnesota earlier this year.
Yeah, it's a great cautionary tale for teams that work with experts in terms of making sure that you really understand what you're putting out there in a report before you finalize it. But Katherine, let's move on from experts. Why don't you choose one of the hypotheticals and we'll go into that one.
Okay, I want to talk about hearsay. There was a point in time when I wanted to write a book on hearsay because although that probably would not have been nearly as interesting as some of the AI books that I've written. I'm not saying that those are scintillating either, but it might have been more interesting than my hearsay book that I'd always planned to write. Because hearsay is often a misunderstood rule of evidence. And there really are some potential hearsay issues, some of the AI tools that are out there, particularly chatbots. So let's take the example of a chatbot responding to a query that is presented to it.
Okay, so I'm going to give an example. I'm in an office and I use a chatbot my firm has created, and I ask the chatbot a question and it gives me an answer. Later on, there's a lawsuit, and the document request that the plaintiff serves on the company asks for digital materials that could cover the chatbot.
Right. And so there's really not much of a question that if the chatbot's answers have been retained in some form of digital form, they'd be considered discoverable material. We are now used to having text messages and Slack and every form of digital artifact be produced as part of litigation. That's part of this lovely American litigation discovery program. But let's assume that the chatbot gave an answer to a query that formed the basis for some action that was then taken by the company that is somehow relevant to the lawsuit. And one of the questions becomes, is that answer a business record? Does it fall under a hearsay exception, or is it not hearsay at all if the, for instance here, plaintiff seeks to admit that answer to the query as a piece of affirmative evidence in the lawsuit? So here are possibilities that we're going to just put on the table. Business record, not hearsay at all, or some other hearsay exception.
So maybe we should start kind of at the beginning. It's possible it's not hearsay at all. If the plaintiffs want to use it just for the fact that the chatbot gave a particular answer and not for the truth of that answer.
You know what? That is exactly the issue that came up again and again and again, and that was so sorely misunderstood by a lot of folks, and was one of the reasons I wanted to write that book, which is people need to take on board that if you're using a writing, not for the truth of the writing, but just for the fact that it was said, that's not hearsay. That's not a hearsay purpose. A hearsay purpose is when you want to use an out-of-court statement for the truth. So if you're not using it for the truth, it's just not hearsay. So I find that to be a really important evidentiary point for people to hold on to. But Anna, what if the plaintiff does want it for the truth?
Then I think we get into those other two options you talked about. So we'd have to think about whether it's a business record or an admission.
Right. I actually had forgotten to mention admission, but you're right. It would be not only business record, but also the question of whether it's a party admission. So for business record purposes for the hearsay rule, then you have to remember, and again, this is one of those things that a lot of people just sort of forget about, that business records are things that are created in the regular course of business. And look at the case law in terms of whether or not it's ordinary course or regular course and how that gets interpreted in terms of how often something has to be created, how unusual the document can or cannot be. Board records, for instance, board minutes would be regular course of business, but a one-time email that had been unsolicited might not be. So it gets very complicated. You have to look at every jurisdiction. But the query here, that is the chatbot's answer, the question it will be, was it created in the regular course of business or was it a one-off? And how does the particular jurisdiction deal with that answer to the query in terms of whether it's considered to be an actual business record?
Yeah. I mean, again, I just think it's so important to emphasize what the chatbot is, like how it's designed, what its interfaces can really affect the answer to that question. And we have all kinds of, I mean, we're talking kind of about a general chatbot right now, but we have all kinds of like fit for purpose tools that are intended to be used in a specific way. And maybe the answer is different in different contexts. So if, for example, the chatbot is used all the time for a certain kind of query, that might come a lot closer to regular course of business.
Right. And these are going to be very fact intensive issues that are going to come up. It's going to be questions about how the chatbot is used, what kinds of questions are posed, what kinds of answers are given, how frequent they are. It's really going to be fact intensive. So let's move on to whether or not the answer a chatbot gives could be a party admission.
That's a really hard one because you could get into whether the chatbot is able to make a statement for on behalf of the company. It's not really an employee, let alone anyone of like true status within the company, right?
At least not yet. But if the chatbot today, let's just take today, was trained by the company or fine-tuned by the company with their own data, their own documents, the question will become, well, does that change the analysis? The chatbot could, by implication, be dealing with and basing its answers on statements that are down the line made by individuals from the company. On the other hand, they're being fundamentally altered and changed by the way in which the internal architecture of the model works. So I think I could make a number of arguments that the statement from the chatbot under those circumstances is not an admission. And I also probably could make an argument that it is.
Yeah, and it may depend on whether it's a repeated question with repeated answer that follows pretty direct guidance that the chatbot was trained on. And I also think we have this emerging question of role that I mentioned earlier, and kind of dismissively, but actually we may start seeing chatbots given certain roles, like in certain meetings or as kind of challenges to boards, for example. It's quite interesting to think about how, particularly with agents, we may put them in certain roles within a company. So that's a pretty open area, just because I think we're talking about a simple chatbot here, but the possibilities may change as the technology changes. And of course, that's always true in the AI space.
Yeah, we're going to end up, I think, on a spectrum where something is anywhere from a mere tool to forming or performing the role of an agent that takes on certain, as you were saying, roles within the company that were or had been normally performed by a human. And we're going to have a lot of really complicated, fact-intensive questions.
Yeah, these are going to be super, super, super interesting and pretty complex to resolve over time.
Right. So the point out there for the lawyers in our audience is that there's going to be a lot of open greenfield questions in the legal area about the evidentiary use of AI digital records, and here that we've been talking about sort of chatbot digital records. And I think we're going to have different cases come out different ways based upon different fact scenarios. So we'll get to different fact scenarios as they arrive and maybe use them for different episodes. But that's all we've got time for today.
I'm Anna Gressel.
And I'm Katherine Forrest, and we're going to leave you with a cliffhanger about additional evidentiary issues for AI.
Thanks for listening to Paul Weiss Waking Up with AI. Be sure to subscribe in your favorite podcast app to stay up to date on the latest in AI policy, law, and governance. For more information on Paul Weiss, go to our website at www.paulweiss.com.